All right, so check this out. We have 9 Supreme Court justices who can barely agree on what to have for lunch. And yet, they unanimously just dropped a legal bombshell that is fundamentally changing every police training manual in the country as we speak. And no, this isn't just another boring legal update you'll see on the nightly news. Folks, this is the single biggest earthquake to shake up police use of force in decades. And what triggered it is going to blow your mind. It all started with a simple traffic stop that lasted less time than it takes to load a magazine. But in those few seconds, the entire justice system got turned on its head. So, if you've ever been pulled over, if you carry concealed, or if you simply want to know how to protect your family and your rights, you need to listen up. Go ahead and hit that subscribe button, because this affects every single one of us, and I guarantee you haven't heard the full story anywhere else. The 5-second incident that changed everything. Let's break down how this all started. Imagine a routine Thursday evening. An officer, let's call him Martinez, pulls over a car for unpaid parking tickets. The total amount? $47. Less than a couple of boxes of 9mm right now. The driver was a 23-year-old named Marcus Thompson. He had no criminal record, no warrants, no weapons in the car, and by all accounts, he was polite and cooperative when the officer first walked up. But in exactly 5.2 seconds, the situation went from routine to catastrophic. Thompson decided to drive away. The officer jumped onto the hood of the moving car, and 2 gunshots later, a life was over. Now, what happened next in the courts is where this gets truly insane. For years, the lower courts used a legal doctrine called moment of threat analysis. That's a fancy term for something pretty simple. They would essentially hit a pause button and look only at the exact split second the trigger was pulled. Everything that led up to that moment, the officer's actions, his decisions, whether he escalated the situation himself, none of it mattered. It was all ignored. This created a legal blind spot, a loophole, and this is the part that should make the hair on your arm stand up. That exact same twisted logic was used to justify police shootings in over 4,000 cases a year across the United States. Thompson's family fought this for 8 long, grueling years. They spent their life savings on lawyers, watching court after court throw out their case based on this flawed, narrow view. But they didn't give up, and their fight led to this landmark Supreme Court ruling. A ruling that will change how you think about every police encounter you ever have from this day forward. The manufactured danger loophole. So let's get into the weeds of how this loophole actually worked. Because once you understand it, you'll see how broken the system really was. They call it manufactured danger. Under the old rules, an officer could, intentionally or not, create a dangerous situation, and then use the very danger they created as the legal justification for using deadly force. And the courts would back them up, almost every time. Here's how it would play out. An officer makes a routine traffic stop for something minor, like a broken taillight, but instead of being professional, they come out hot. They're screaming commands. Maybe they draw their weapon immediately. Or they do something tactically unsound, like planting themselves directly in front of the car's only exit path. Now, you, the driver, are suddenly dealing with a high-stress, confusing situation. Your natural reaction might be fear, confusion, or a flight response. When you react, the officer then claims to feel threatened by your reaction and uses force. The courts would then look only at that final moment, the threat, and completely ignore the fact that the officer's own aggressive actions created the whole mess in the first place. And this wasn't some rare thing. Civil rights attorneys have documented nearly 3,000 cases in the last 5 years where this exact pattern played out. Even worse, some police training manuals were actually teaching this as a valid tactic, calling it tactical positioning for officer safety. Some departments even had internal memos calling it proactive threat management, a sterile, corporate-sounding euphemism for creating your own justification to use force. Thankfully, the Supreme Court just called this practice exactly what it is, a constitutional violation that turns police encounters into legal traps for citizens. The payoff. What this means for your self-defense rights. Okay, so let's get to the part that matters most to us. What does this ruling mean for you, the responsible gun owner, the person who carries a firearm to protect themselves and their family? This might be the single most important legal development for self-defense rights in decades, and almost nobody is talking about it. The Supreme Court was crystal clear. You do not lose your constitutional rights just because the person escalating a situation is wearing a badge, especially when that person created the dangerous situation themselves. Think about this terrifying scenario, one that we hear about far too often. A no-knock raid hits the wrong house at 3 a.m. The homeowners, believing they're being invaded by armed criminals, grab their firearms to defend their family. Under the old, broken legal framework, a court would only look at the moment the homeowner pointed their gun at the unidentified figures who just broke down their door. The fact that the police were at the wrong house and never announced themselves was often dismissed. The Supreme Court just said, no more. They specifically ruled that this approach violates the Fourth Amendment. They used the phrase, precipitate the violent confrontation through their own unreasonable actions. This means your castle doctrine and stand your ground rights don't just vanish into thin air because the person you're defending against later turns out to be law enforcement who made a catastrophic mistake. Now, let's bring it out of the home and into your vehicle. This ruling also has massive implications for concealed carriers during traffic stops. An officer can no longer automatically claim that your lawfully carried firearm creates a reasonable fear for their safety, especially if their own actions are what escalated the encounter. Your calm compliance and the legality of your firearm are now powerful evidence in your favor. And here's the real kicker. The court specifically referenced the right to resist an unlawful arrest, a concept that has been largely dormant at the federal level for over 40 years. Legal scholars are calling this the biggest expansion of individual rights since the Miranda decision, and it directly protects lawful gun owners from government overreach. The numbers don't lie. Now, if you think these scenarios are just outliers, let's look at the hard data. This is why this Supreme Court decision was so desperately needed. Last year alone, 1,096 people died in police shootings. But here's the stat nobody talks about. 73% of those incidents started over minor issues, things worth less than $200. We're talking unpaid fines, broken taillights, stuff that should never escalate to deadly force. Even more shocking, internal police data revealed that 89% of officers involved in fatal shootings had prior complaints of aggressive behavior that were either dismissed or ignored. The Department of Justice quietly released a study showing that departments pushing warrior training, teaching cops to see every citizen as a threat, had 400% more use of force incidents than departments that focused on de-escalation. And the final gut-wrenching number, only 1.2% of police shootings ever lead to criminal charges against the officer, even with clear video evidence. The system was failing, and the Supreme Court finally stepped in. The real drivers of change: money and technology. But here's the part the mainstream media won't tell you. This massive shift isn't just happening because of a court ruling. It's being forced by two things that always get people's attention: money and technology. First, let's talk about money. Police departments have liability insurance just like you and I, and those insurance companies are getting hammered. Premiums for police departments have skyrocketed by over 800% in the last 3 years. We're seeing departments go from paying $50,000 a year to over $500,000. In Texas alone, 23 smaller departments had to completely shut down because they couldn't afford insurance anymore. The average settlement for a misconduct case is now $1.8 million, and taxpayers are the ones footing the bill. So insurance companies are now acting like auditors. They are forcing departments to adopt de-escalation training, mandate body cameras, and fire problematic officers. If they don't comply, they lose their coverage. Period. Second, technology. Body cams, dash cams, and every citizen with a cell phone are changing the game. We now have advanced software that can analyze thousands of hours of footage. It can track an officer's positioning, analyze the stress in their voice, and determine if they followed protocol. Experts can now prove, with data, that an officer who stands directly in front of a car is 340% more likely to shoot. They can prove that an officer who starts an encounter with aggressive language is 520% more likely to have it turn violent. This technology is forcing accountability. Officers know that every word, every movement, and every decision is being recorded and can and will be scrutinized. How this changes every encounter you have. Okay, so let's bring this all home. What does this mean for you, starting right now? It means the rules of the game have changed, and they are heavily tilted in favor of the citizen who knows their rights and stays calm. 1. Blackmail is now. Compliance is now a shield. If you are carrying, and you properly announce it, keep your hands visible, and follow commands, the court must now consider that as evidence in your favor. Your calm, lawful behavior is your best defense. 2. Escalation is a liability. Officers who unnecessarily escalate a situation can now be held legally responsible for creating that danger. The entire interaction is now under a microscope, not just the last 2 seconds. 3. Paralysis. Is your phone your best witness? Your cell phone footage just became exponentially more valuable. That recording proves whether you were calm and compliant, and whether the officer's actions were reasonable from start to finish. The key takeaway is this: your conduct during an encounter builds your legal case in real time. Every calm word, every steady movement, every second you remain respectful is another brick in your legal wall of defense. The power has shifted. Look, what's happening right now is the single largest shift in police accountability in half a century. The old, broken system of ignoring how a situation started is officially dead. And that means your rights during any police encounter are stronger today than they have been in decades. This isn't about being anti-police. It's about being pro-Constitution and pro-accountability. So, what do you think? Do these changes make you feel safer? Are you concerned about how this might affect officers on the street? Let me know your thoughts down in the comments. And if you want to stay on top of the critical updates that impact your rights, be sure to hit that subscribe button. Stay safe, stay informed, and remember, in today's world, knowledge of your rights isn't just power, it's protection.